So we will start today. Where are others? They are coming. Chaliye. So now we will start with the part 3rd of the constitutions, that is known as a fundamental rights. So what is rights? You all know. You know your rights? Do you know your duties? So what is rights? Equality is right. I am not asking about the features of rights. I am asking about what is right. When you are asked what is right, you need to define the right. So what is rights? Do you have a rights? Yes or no? Okay. So what do you mean that you have? Right means what? Now don't give me example, right to eat, right to sleep. These are examples. So what is rights? सबको मानना है. This is rights. Compulsion. Right is a compulsion. Compulsive. But these are the characters. I am asking what is right. Define the rights. So who will going to define? Tell me. नहीं. तो आपको किस में बोलने में समझ में आएगा उसमें बताइए. यू वांट टू एक्सप्रेस योर सेल्फ इन गेस्चर, आप उसमें बताइए. राइट्स में क्या समझ में आ रहा है आपको? Every country allows so it is allowed by the country. He is saying it is good. Good or goods? Goods. Good. The right is good. No. What is citizen? Yes, citizenship is a relationship between state and individuals, and right is a claim of an individual against the state. So what is right? Right is a claim. Claim of whom? अभी तो शुरू किया है. अच्छा लास्ट क्लास का. हाँ एक मिनट बस. Claim of individual. Against whom? Against state. So this is right. तो ये good नहीं, bad नहीं. This is not compulsion. This is not what you are saying. What you are saying about right? So this is not. This is a claim of an individual. So this is not what state can give, but rather states are bound to give because this is a claim. And do you understand the meaning of claim? What is claim? Everyone has its own. This is their demand. So the country has to give them. ठीक है? This is claim. Yes sir. Now what you want to ask? पूछिए जल्दी. हाँ. Okay. So what is Article 5 is about? Article 5 talks about that who are considered as a citizen at the commencement of constitutions. Very simple. So it's a any person who fulfills two conditions. Out of the two, one is compulsory. The person has to be domiciled in India and born in India, or either of his parents born in India, or residing in India for the continuous of 5 years before the commencement of the constitutions. So the person will be considered as a citizen at the commencement of constitutions. So what did you not get in this?
Does that two simultaneously required or?
One is compulsory.
That
First, domiciled. If no one is domiciled, so he will, if he is fulfilling all the conditions but he is not fulfilling the domicile, he will not be considered as a citizens. So one is compulsory, he has to be domiciled. Then others are optional, either of the three, one has to be there. This is the conditions. Okay. Naturalization is a conditions through which any individual who has no connections whatsoever with the India wants to be a citizen of India. Any foreigner means foreigner. No connection means no is a foreigner. So how a foreigner can have an citizenship? आज हमें कुछ लोग कम दिख रहे हैं. Strength is less. Why? अच्छा, there is an exam. अच्छा, इसलिए नहीं आए वो लोग. वैसा ही होता है, एग्जाम छोड़ देते लोग. So naturalization is this. Do you get that? Registrations. हाँ, रजिस्ट्रेशन अप्लाई करने से पहले उसको कंटिन्यूसली इंडिया में रहना होगा. कंटिन्यूसली मीन्स एक दो दिन का गैप हो, दो कंटिन्यूसली डज नॉट मीन कि एक सेकंड. ही इज लिविंग इन कंटिन्यूसली इन इंडिया, देन ही will register, then the government will decide whether to provide or not. This is naturalizations. Registrations, anyone who was or who were to be a citizen or has any link to the India, now having a citizenship of another nations, now want to be a citizen of India. So what he has to do? He has to just register with the consulate जो है ना, और embassy, जो भी मतलब जिस भी country में, there have to be registered. He has also condition that he has also to be in live in India before the registrations continuously. No, that is depending upon. Some has 7, 11 the conditions. ठीक है? Any doubt? Any और doubt?
वो इंडिया में आएगा, उसके बाद जो कंट्री में रहेगा काउंसलर ऑफिस पे जाके रजिस्टर.
नहीं, यहाँ भी रजिस्टर कर सकता है, बट रजिस्ट्रेशन से पहले he have to show his interest to have an citizenship. Like example तुम आपको अदनान सामी. Do you know अदनान सामी? नहीं. He is a very famous singer. So he was been in India for before getting an citizenships through registrations. Is it clear? Yes or no? Okay. So now we have seen what is right. ठीक है. तो rights are claim against the. So it is a claim of a citizen, claim of an individual, not a claim of an state. And it is to be a claim of individual against the state.
If one person stayed 10 years.
अब ये क्या मतलब? One person stayed 10 year 11 month.
No, sir. Within 12 years, if he just.
The condition is condition. ऐसा क्वेश्चंस क्यों लाते हैं? 10 years, 10 year 11 month, 10 year 6 month.
No, sir. If he got sickness, then he went outside the country.
तो सिकनेस यहाँ इलाज नहीं हो रहा है?
Suppose, sir, for 1 year.
ये यहाँ इलाज नहीं हो रहा सिकनेस का? यहाँ हॉस्पिटल्स नहीं है? जितने बीमार हो सारे बाहर जा रहे हैं. You got sickness, so you get. ऐसा थोड़ी 10 साल में पहली बार होगा. और if he going for any, like you said that he go for the treatment, any operations which is available only in the US, तो permissions तो होगा ना, that you are going to have this, documentations तो होगा ना? Yes or no? Living in India does not mean that you cannot leave country. Living, you're staying here, you are visiting for your any business purpose or anything, but you are staying here. This is living means. ठीक है? अब वो बीमार हो जाए, हनीमून में चला जाए, तो वापस तो आएगा ना? तब नहीं आएगा, तो फिर नहीं मिलेगा. So this is rights. Is it clear? Now my second question. Why the topic says fundamental rights? Why not only rights?
of the individual. That's why it is fundamental right.
Like basic need, like. So what is human rights? So if it is a basic need, because of this it is known as a fundamental right. So in UK, their rights is not a fundamental right, they have only rights. So it means they do not provide a basic needs. So what do you mean by the basic needs? Can you define? Like so this rights only talk about the khana, pina and sona. These are the basic means which is necessary. That basic is a human right. Basic is a human right. And this is not the reason why it is known as a fundamental right. थोड़ा और सोचिए. Why it is known as a fundamental right? Why not only rights? Yes.
Guaranteed.
Yes, because it is guaranteed and it is protected. Guaranteed and protected by the court. That's why it is known as a fundamental rights. So it is right because it is a claim of an individual against the state. It is fundamental because these rights are guaranteed. These rights are protected. What does it mean? It means that if anyone's rights are violated, the state or judiciary is there to protect their rights. The states and judiciary are there to restore the violative of the rights, and also they have power to punish who violates that. And nature of the right of protected and guaranteed, it is a fundamental right. Yes or no? Chaliye. So now we will see. So part 3rd of the constitutions contain the fundamental rights which is given from article 12 to 35 of the constitutions. It is also known as a Magna Carta. So Magna Carta of Indian Constitution is a fundamental right or part 3rd. Why? So what is Magna Carta?
Written law.
So Magna Carta is a kind of one document which was signed in 1215 in Europe. So there was a king in Europe during this period, and he was very cruel. So the citizens of his kingdom has forced him to sign a document as a Magna Carta, under which they have promised or they have been promised to be provided with the basic necessity of the rights. Right to religion, right to temple. Right, these rights are also not provided to them. So they have forced the king to sign a document. The document is known as a Magna Carta, and because of this it is known as a Magna Carta. And we have taken the fundamental rights from the Bill of Rights of USA. Clear? Yes or no? Is there any difference between Indian fundamental right and Bill of Rights of USA? Yes, we have discussed this, if you remember. Parliamentary sovereignty and judicial supremacy. There we have seen that in USA, the judiciary has absolute power, supreme power. They can suspend the law, they can suspend the rights, they can amend the right. Yes or no? In UK, it is Parliament who can suspend without uncontrolled power. But in India, it is not an uncontrolled power. So judiciary is there to protect the rights. Any action of the legislative, executive, or even a private individuals hampers the rights. Clear? Yes or no? Actually, now we'll see the feature. Some of the feature we have already been discussed. Just we will Go through it. Some of the fundamental rights like Article 15, 16, 18 clause 2, 19, 29, 30 are available only to the citizens. And rest of the rights are available to all persons residing in India. Do you remember in the last class we have discussed the resident of India is divided into citizen and alien. So difference, why this division is there? Because some of the post public offices are reserved for the citizens and some of the rights are also reserved for the citizens. So these are the rights which is also only available to the citizen of India, not to all resident of India. Getting my point? Yes or no? Next, they are not absolute but qualified. What does it mean? So they are not absolute right.
It can be.
What is absolute? What does the term absolute means? Absolute means without any restrictions. So rights are not absolute, they are qualified, means they are been come with the restrictions. So that it is a state who can restrict the enjoyment of your rights. Yes or no? Next. Some of the rights are negative in characters. What does it mean? Negative in character means there are certain rights which is imposing or putting limitations on the state from doing anything. Like Article 14, 15, 16, which says that the state cannot discriminate among citizens. It is restricting. Yes or no? 14, 15, 16, 18, 20, 22, 28. These are the rights which are negative in character. It means they are putting limitations on the authority of the state. So they are restricting the state to taking any action. Like 15 says, the state cannot discriminate among its citizens. 16 talks, the state cannot discrimination on the given ground in respect of the public employment. Yes or no? Then 18, state cannot give anyone's any title. So it means it is putting restrictions on the power of a state. Similarly, Article 20, protections in terms of convictions. So state cannot give anyone double punishment. It cannot force anyone to give witness against himself. Right? Article 22 is also state cannot, it is giving protection against the arbitrary arrest. 28, it is giving protection against the religious instructions into the educational institutions. So state cannot provide anyone religious instructions. It means it is limiting the state power. So because of this it is negative. Whereas some of them are positive in nature. How positive? They are allowing the citizens to do something. Article 25 talks about what? You are free to perform, you are free to follow your own religion. It is meant, it is encouraging the citizens to do this. Similarly, Article 29 also encouraging the citizens to establish or to secure, preserve your own culture, your own linguistic, your own script, if it is distinct. Are you getting my point? So because of this, there are certain negative characters, there are certain positive characters of fundamental rights. Like 29 and 30. It is conferring us certain privileges on the persons. Clear? Okay? Next. So they are justiciable. Now what does the justiciable term means? Justiciable means what? Yes, if anyone's rights is violated, they are been forced to visit the court, and court is there to restore the violated right. So because of this, justiciable. It is justiciable, so because of this it is known as an legally enforceable. So they are justiciable, allowing the persons to the court for their enforcement. And legally enforceable, it means the court can compel the authority or the person who has violated the right to restore, and also it can punish any authority for violating the rights. Getting my point? Yes or no? Right? So they are defended and guaranteed by the Supreme Court. They are not sacrosanct or permanent, right? They can be suspended, they can be repealed, like right to property, which has been repealed, and now it is an constitutional right, legal right. Yes or no? So it is not a permanent or sacrosanct, that once it has been granted, it cannot be taken back. So this is not such. It may be repealed also. The state can take away also the rights. So the parliament can curtail or repeal them, but only by a constitutional amendment act and not by an ordinary act. Clear? Okay? Next, they can be suspended during the national emergency except Article 20 and 21. So during 352, Article 352, which talks about a national emergency. So when there is a national emergency imposed in whole part of the nations or any part of the country, it can be suspended by the order. But Article 20 and 21 cannot be suspended. Yes or no? Okay. Now, their application can be restricted while martial law is in force. This is talked by Article 34. What is martial law? Yes, martial is military. So what is military law? So is there any situation when we have a martial law? South Korea. I am talking about India. I'm not talking about the world. These rights which we are discussing in the terms of India. So do you have any situations when we... What is martial law? Curfew. Do you understand curfew? What is curfew? When the civilian law and order has been placed in the hand of army, कहीं riots हो जाए या any disaster, so वहाँ पर army चली आती है to take over the civilian control for the certain period. So that is known as a martial law. Section 144, धारा 144. You might be heard about this, right? So this is dealt under Article 34 of the Constitutions. Clear? So martial law, law when army take over the charge of civilian law and order. See, in this area, law and order maintenance is under responsibility of DM, right? DM or DC, whatever you can call, district magistrate. But consider some situations when the situation is out of control, which the DM is not in a place to control the law and order. So he will call a army. So that time it will be known as a martial law. So during that period, during the period of martial law, the rights will be curtailed.
It's 2020.
No, any law. 2021 is except in national emergency. So when there will be a martial law, you will be curtailed, not suspended, curtailed. Restrictions will be imposed on enjoyment of your right. There is a difference between the suspensions and curtail. What is suspensions and curtail means? Suspension means you will not be restricted to enjoy your right. But if any violation will be there, you have no right to move to the court because that right is suspended for that period. This is suspensions. Curtailment means restrictions will be imposed from enjoying of that right. Like suppose in the martial during this period, COVID, there was restrictions that you cannot move from here to here. You cannot be in a more than 2 or gathering. You cannot gather. Restrictions was there now. Yes or no? And that then will be a restrictions. So the application of restriction. So there will be restrictions on the enjoyment of the right during martial law. It is not suspended. Do you understand the meaning between the difference between the two terms, suspended and restrictions? How many of you do not understand? 1, 2, 3, 4. Restriction. What is restriction? Restriction is allowed. See, restrictions, it means it is putting in limitations on the enjoyment of your right. Like suppose, if I say that the area is restricted, it means no one can enter into the area. So restriction is there, right? Suspended, it means whether you enter or not, that is now it is suspended. So the right, like suppose if I say the right to speech and expression is restricted, means you are allowed to speak but with the certain limitations. This is restrictions, not with the full enjoyment. This is restrictions, yes or no? When the right is been suspended, it means now this right is suspended, so it is up to the authority. So they can curtail your enjoyment. So you are speaking, there is no restrictions on your speaking. But if any restrictions, or if it was your right is violated when it is suspended, so in case of suspensions, you cannot move to the court for the violation of your right, because the right during that period is suspended. So you cannot enjoy that right during that period. This is suspensions. Restrictions, you are enjoying the right, but with the limited with restrictions. This is restrictions, yes or no? Am I clear? Okay? So this is restrictions. Now most of them are directly enforceable. What does it mean? It means that there are many of the rights which are directly been applicable and enforceable. There is not required any support. But there are certain rights like 15, 17, 18, 23, 24, which requires an act to be implemented. And because of this, they are known as an not self-executory. No, you didn't get. No. Article 17 talks about abolition of untouchability. So Constitution says that untouchability should be abolished, and practicing of untouchability in any form punishable by the law, under the law. What does it mean? It means the Constitution has abolished. But if anybody practice untouchability, so the person will be only punished if there is a law for that punishment. So if there is no law which is abolishing or which is restricting the practice of untouchability, so court cannot punish that person. Yes or no? No? Still not? How many of you did not get this? Article 14 is what? It is says that right to equality. What does it mean? That every person is equal, whether any law has been there or not. So everyone is equal, right? It means you are equal to book ticket in a train. You are equally book move here and there. You are equally equal to go anywhere, right? If you have any crime is against happens you, so you are equally to go and report your crime. This is equality. Does it require any law? No. Article 17 says untouchability should be abolished, but the constitutions in certain articles talks only its abolitions, and it says that if anyone practice again after the abolition of the untouchability, so the punishment court can only give a punishment if there is a law for that offense. So if the law is not for the made by the legislature for that act done by any persons for a punishment, so the court cannot give any punishment. What does it mean? It means, suppose that Article 17 has abolished and he said no one can practice, but still someone practice untouchability. So against whom it was practiced, so he will move to the court that this person or this authority has practiced an untouchability, and on the basis of untouchability some this that is violated. Clear? Now the court, this is an abolished, but still we cannot or still cannot be restored because there is no law. So there are certain articles in the constitutions which requires and law for their implementations, like child labor. So constitution says child labor cannot be practiced in any form. But what if someone practice? How? And does not talk about through the law. So if there is a law, then only can be punished who violated child law. If there is no law, so the court cannot punish. So if that there is no punishment, so no one. Abolition. Are you getting my point? Yes or no? Which means that if any article which requires and back law for their implementations, and if there is no law for the implementations, it means they are not self-executory. With executed self, for the execution of that article, it requires an backing of the law. Am I clear? Now it is clear, yes or no? Clear? So there are certain articles like 15 clause 2, 17, 18 clause 3 and 4, 23 and 24. These are the rights which are not self-executory. Rest of the rights are self-executory, means they have been executable without any law. Right to life. Does it require any right, any law to be right to life? No. It is available without any law. Yes or no? Is it clear? So this is an features of the fundamental rights. Now we'll see the definitions of state, Article 12. Now this state, definition of state is different from the state what we in the context of political science. We have seen this definition of state. Yes or no? No. Right? Populations, territory, government and sovereignty. So this state is different from that. That state is universally accepted at the national level when an entity can be defined as a state as a political context. This definition of state is only for the part 3rd. Because many of the articles of the part 3rd talks about the state cannot discriminate. So we need to know state means what. The definition has to be there for its clarity, or yes or no. Otherwise it will be an unambiguous term. Ambiguous term where it required the meaning is not clear. It is very haphazard. So to clarify the term state, Article 12 talks about that whenever the term state appears in the part 3rd, what does it mean? Are you getting my point? Am I clear? So in this part, unless the context of otherwise required, the state includes. So first, whenever the article says state, it means government and parliament of India. Whenever it says state, means government and legislature of each of the states. Whenever it says states, it means all local and other authorities within the territory of India or under the control of government of India, like panchayat, local government, municipality. So this all comes under the definition of state, or those who are having a control of government of India, like schools, or those who have a stake in government of India, like public sector units, LIC. LIC is a state? LIC is a state? Can LIC come under the definition of state? Yes. Why? Because the government has a stake in it. Can the banks, nationalized bank, SBI, Bank of India, Bob, Bank of Baroda, they are a state? They are a state? Yes, because the government has a stake in it, more than 51%. PSUs, हाँ जी बोलिए. PSUs, तभी तो PSUs है वो. मैंने आपको कल बताया था ना, कल या परसों, वी हैव डिस्कस डेमोक्रेटिक सोशलिज्म. नहीं, डेमोक्रेटिक सोशलिज्म.
Yes, sir.
What is democratic socialism? Where the government means of productions and manufacturing has been controlled not only by the government but private player also allows. So bank का example मैंने आपको दिया था, where the private players are existing. So that's how you need to link. तो democratic socialism means the government has a stake. तो जितने भी PSUs हैं, चाहे वो LIC हो, ONGC हो, IRCTC हो, Indian Railway ho. Are you getting my point? So these are state. So this comes under the definition of state. Am I clear? Can BCCI be a state? BCCI, Board of Control of Cricket in India.
Yes, sir.
Is it a state? No. State? It comes under the definition of state. Yes or no? It is not state? Government of India? No, BCCI. Board of Control of Cricket in India. No, it is not a state. It is a private body. कैसे? Government has no role in electing or selecting the president. This is a private body started in Chennai, Tamil Nadu. वो फिर BCCI हो गया. So this is a private body. Hollywood, Bollywood, private body. ठीक है? So state has no role in it. So it is not BCCI. Is court comes under a definition of state? Court, judiciary, Supreme Court, High Court comes under the definition of state? Yes? No? Yes? No? No? Yes? Those who are giving answer yes are correct. Those who are saying no, they are also correct. So court, judiciary have a two functions. One, they are acting or they are pronouncing the judgment, means they are doing, you can say that they are been performing the judicial functions. Judicial function, pronouncement of judgment or any court, right? Second, they are also doing administrative work. एडमिनिस्ट्रेटिव, जैसे कोर्ट में लोग काम करते हैं, टाइपराइटर होता है, स्टेनो होता है, सेक्शन ऑफिसर होता है, कोर्ट में होता है, हाई कोर्ट के वैकेंसी निकलती है, यस और नो, वहाँ लोग काम करते हैं, ठीक. कोर्ट में रजिस्ट्रेशन होता है, मैरिज रजिस्ट्रेशन होता है कोर्ट में, और भी रजिस्ट्रेशन हैं, तो वो एडमिनिस्ट्रेटिव फंक्शन है कोर्ट का. So administrative, do you understand now? So administrative functions of the judiciary is under the definition of state, whereas the judicial functions of the state is out of the definition of state. Nahin? Administrative function of court is under the definition of state. Administrative functions, it performing admin. The judiciary has their own power to regulate their own affairs. Judicial affairs नहीं, administrations संभालना, वहाँ पर लोग कोर्ट में काम भी तो करते, टाइपराइटर होता है, then there is a आप steno is there for the high court, many vacancy निकलती है हाई कोर्ट में, so they are performing administrative, so that when they performing the administrative functions they are coming under the court state. When they are being performing the judicial pronouncement, judge सजा और court का trial or everything, that is beyond the scope of state. Is it clear? Yes or no? Salary और कौन देगा उनको सैलरी? खुद से वो अपनी खेती थोड़ी करते हैं पैसों की. कंसोलिडेटेड फंड ऑफ स्टेट इंडिया से तो जाता है सुप्रीम कोर्ट के लिए, हाई कोर्ट के लिए कंसोलिडेटेड फंड ऑफ स्टेट से जाएगा. एम आई क्लियर? एनी डाउट? नहीं? So this is Article 12 of the Constitutions. ठीक. Now we will move to the next. So next is Article 13, but we were not going to discuss Article 13 as it is given in the Constitutions. So we'll understand the Article 13 through concept which is known as amendability of the fundamental right. Here in this we are going to see series of amendments, series of cases, series of judgments, and also doctrine of basic structure we will also discuss here in the segment. ठीक है? Any doubt? So now we'll discuss whether the fundamental rights can be amended or not. Today we all know it is be amended. But when the Constitution was commenced, 1950, this debate arises as the commencement of constitutions was done. So why this question was there? What is the reason of debate or disputes or confusion? Why this question arises, whether it can be amended or not? Parliament has a power to amend, so it can amend. So why there is a debate arise? Why the amending or amendments of the Parliament was continuously keep on challenging in the court? What's the reason behind this? So this confusion or this question arises just because of the two articles of the Constitutions. The first article is Article 13. So Article 13 of the Constitution do what? It put restrictions on what? On a parliament to make any laws. So it says that if law which is inconsistent, derogatory, which violates what? Any of the fundamental right. So law which has been made by the Parliament, and if that law violates any of the fundamental right given in the Part 3, that law will be void, will be unconstitutional. This is Article 13 is about. This is talking 13, right? Okay. So but Article 368 on the other hand, so Article 13 is doing what? It is restricting, putting limitations on whom? On Parliament, that you cannot make any law which takes away anyone's fundamental right. You have no power to make law. It means it is putting the limitations on the power of Parliament to make changes or to make amendments to the fundamental rights. This is Article 13 saying yes or no.
Yes.
Whereas on the other hand, Article 368 empowering the parliament that you can amend the constitutions. So one is saying you can do whatever you want. Another is saying you cannot do this. What will happen? Clash, dispute, conflict will be there, yes or no? And because of these two articles, Article 13 and 368, there is a conflict arose. Now whether the parliament can amend or not. Because parliament using 368 amend the fundamental right. People, those who are affected by the amendments move to the court. That parliament cannot do this. Why? Because Article 13 is restricting parliament. Okay. So it is unconstitutional. So again parliament doing under 368, again it was challenging. So now there is a debate, confusion, conflict going on the country, whether it can do or not. Whether the amending power of the parliament under 368 covers fundamental rights or not. 368 says you can amend the constitution. 13 said you cannot make any changes to part 3rd. It means that part 3rd is not part of constitution, because 368 is saying you can amend the constitutions. So if I can amend the constitution, it means part 3rd can also be amended if it is a part. But you are saying you cannot do anything, it means it is not a part of constitutions. So these are the debates or confusion was there in the country initially because of the two of the articles. So now we are going to discuss that while parliament using 368 can make changes to fundamental rights or reject amendment, so can it reject, can it restrict, or Article 13 stops parliament from amending the fundamental right, or the Article 13 come into the place of the amending of the fundamental rights. So this all has been debate. So by the series of amendments, by series of judgment on the amendments, at the final stage we will be in a positions to answer this question, that what will be the final scenario with respect to this debate or confusion. Clear? Yes or no?
Yes, sir.
Any doubt? Okay. So now we'll start with the very first amendment of the Constitution, first Constitutional Amendment Act. Now one thing you need to keep in your back of the mind, that the period. What period? What I mean? So what you need to understand, or you can, for understanding, for your better understanding, this debate has to be divided into two periods. One, before 44th Constitutional Amendment Act 78, और ये after Constitution 44th Constitutional Amendment Act 1978. Why this period we have taken as a watermark period? Because till 1978 or till 44th Constitutional Amendment Act, right to property was a fundamental right. Which was, by the 44th Constitutional Amendment Act, it was moved to constitutional right. Am I clear? Yes or no? Now what is right to property means?
Means, किसी का प्रॉपर्टी को कोई ले नहीं सकता, राइट ऑफ प्रॉपर्टी मीन्स उसका मर्जी से ही वो कुछ कर सकता है।
ठीक है, वो तो कोई ले नहीं सकता है। चलिए मान लिया आपकी प्रॉपर्टी मैं नहीं ले सकता, आप क्या क्या कर सकते हो अपने प्रॉपर्टी के साथ?
मैं बेच सकता हूँ
Yes.
मेरी मर्जी से।
हाँ हाँ, मैं कहाँ करूँ, मेरी मर्जी से, आपकी मर्जी से ही। तो राइट टू प्रॉपर्टी का मतलब क्या हो गया? यू हैव अ राइट टू एंजॉय द प्रॉपर्टी, you can lease out the property, you can sell out the property, you can control the property. Yes or no? So whatever you want you can do with the property. ठीक है? This is just this, you need to understand, you need to keep this period, watermark period into your mind while understanding. Why I'm saying this, you will come to know. So this First Constitutional Amendment Act 1951. Now many of the questions has been asked from this very first amendment into the examinations. So this is a beauty of the PYQs. Now, why did what is the reason behind the first Constitutional Amendment Act? Why the government come with the first Constitutional Amendment Act? वो भी तब, अभी तो कॉन्स्टिट्यूशन बनी थी। 1950 was a period when the constitution was commenced. 1949 में we just completed. So what's the necessary to come up with the immediately an amendment to the constitutions? Democracy? Demo होगा? Sorry? Inequality. So demo means inequality. Okay. Jamindari systems. So one system is Jamindari system. So country want to abolish the Jamindari system. Why it want to abolish the Jamindari system? Because Jamindari system is creating an inequality in the society. Right? So a committee, there was a committee known as a K. Kumarappa committee. Formed by the government of India. For what? To abolish the Jamindari system. So objective of this committee is to abolish the Jamindari system. So K. Kumarappa committee was constituted, right? Now this committee has recommended, first, sealing of the land, that is limiting the holding of land. And second, to abolish Jamindari system. This was a recommendation of this committee. Do you understand? So first he says the land should be sealed. Now what is sealing of the land? It is putting restrictions. आपको दो कंसेप्ट अपने दिमाग में रखना है. पहला, we are a mixed economy, so we do not believe in Robin Hood system. एक से लो दूसरे को दो. But we have been on democratic socialism at the same time. So what we are need to make the productions and manufacturing given to the share to those also who have been involved in this. So Jamindari system में क्या हो रहा था? What is Jamindari system? Jamindari system is a kind of a systems in lieu of the services. The state provide them the Jamindari land rights. नहीं, मनसबदार आपने पढ़ा होगा ड्यूरिंग दिस मेडिवल. मुगलों ने मनसबदार सिस्टम लेकर आई. नहीं, घोड़सवार और इसके बेसिस पर वो क्या करने लगे, दे ट्राई टू इंस्टेड ऑफ गिविंग देम अ पेमेंट इन अ कैश दे आर अवॉर्डिंग द लैंड। आपने सीता लैंड के बारे में पढ़ा हो, हिस्ट्री नहीं पढ़ा आपने, पढ़ेंगे, हिस्ट्री भी पढ़ेंगे, ठीक है। तो इसी लैंड सिस्टम को ब्रिटिशर्स ने कंटिन्यू किया, दे डू नॉट कम अप विद देयर ओन एनी डिफरेंट administration system. So what they come up, they have extended the medieval period of land system into the practicing. So they have also started to providing an land ownership to the persons in lieu of the services given to company. ठीक है, तो कुछ अरेंजमेंट्स भी किए ब्रिटिशर्स ने, लाइक महालवाड़ी सिस्टम, जमींदारी सिस्टम्स, रैयतवाड़ी सिस्टम्स, शायद सुना हो बहुत लोगों ने आपने से, है ना। सो दीज आर द सिस्टम्स। तो जमींदारी सिस्टम में क्या किया, लैंड ऑनर्स बना दिया जमींदार को। नाउ गिवन कि नाउ यू कलेक्ट द रेंट एंड गिव अस टू अस, वी आर नॉट गोइंग टू कलेक्ट द रेंट, इट इज योर रिस्पॉन्सिबिलिटी टू कलेक्ट अ रेंट एंड गिव टू द ब्रिटिशर्स। ठीक, रैयतवाड़ी डायरेक्टली फ्रॉम द किसान फार्मर्स, महालवाड़ी a group of villages. So this system has created an inequality in the society, exploitation has been done. इसकी वजह से क्या हो गया, bonded labor के there is an increase in the number of bonded labor, ठीक है। Then there is an increase in the exploitations, there is an increase in the landless farmers. There are three types of farmer who has a ample of land, marginalized farmer who has a very small tract of land for their cultivations, and the third one is landless farmer. They are farmer, so landless farmer becomes an labor. So this is a side effect of the जमींदारी। आप इसको हिस्ट्री में अच्छे से पढ़ोगे आप। आई एम जस्ट गिविंग यू द summary. So the country want that the zamindari system should be abolished because they want to end the exploitations of the labor. They want to establish an equality in the society. They want to give everyone the rights. The privileges should be abolished. ठीक है, आर्टिकल 18 बात करता है ना abolition of title. तो जमींदारी, जमींदार, राय साहब, राय बहादुर, ये टाइटल आप हिस्ट्री में, आपको मॉडर्न हिस्ट्री में सुनने को मिलेंगे. दीज आर द टाइटल्स गिवन बाय द ब्रिटिशर्स. सो व्हाट दिस टाइटल क्रिएटेड, दिस इज क्रिएटिंग अ प्रिविलेज. नहीं, दिस इज क्रिएटिंग एन इनइक्वालिटी. तभी आप देखिए आर्टिकल 50 पीसी की बात करता है. आर्टिकल 50 इज व्हाट, टॉक्स अबाउट separation of judiciary from executive. Now why it is talking about, why it is necessary, ऐसा क्या हो गया कि जुडिशरी और एग्जीक्यूटिव को अलग करने की जो बात आने लगी? बिकॉज ऑफ दिस इनइक्वालिटी सिस्टम प्रिवेल्ड, दिस रॉटन सिस्टम प्रिवेल्ड इन इंडिया, द सिस्टम नोन एज अ जमींदारी सिस्टम. कैसे? नाउ तो जमींदारी क्या था? लैंड गिवन टू द पर्सन्स इन लिeu ऑफ द सर्विसेज. जमींदारी नाउ, पहले जब जमींदारी सिस्टम जब इंट्रोड्यूस हुई थी ड्यूरिंग द मेडिवल, सो व्हाट इज इट? इट इज अप टू द, इट लीव्स टू द पर्सन्स. ये लो आप अपना जमीन, इससे आप खेती करो, जो करना आप करो, दिस इज योर पेमेंट इन प्रोवाइडिंग एंड सर्विसेज टू द स्टेट. तो स्टेट उसको जमीन भी दे दी, पेमेंट नहीं करना पड़ा. नाउ जमींदार इज बिन डिपेंड ऑन द दैट लैंड ट्रैक्ट. मनसबदार आप पढ़ेंगे, यू विल कम टू नो अबाउट द मनसबदार. फिर वो देयर इज लॉट ऑफ टर्म, मैं भूल रहा हूँ, वो घोड़सवार और देयर आर मेनी टर्म्स. शाहजहां ने उसमें कुछ चेंजेस किया, 10 घोड़े 20 घोड़े करके उसमें बढ़ाए उसको. दैट्स यू विल कम टू नो. But when the Britishers came, they continue with the system. So what they do now, they ask कि now collect the tax and give us too. And out of the tax, whatever you collect, keep 10% of the tax with you. Rest 80 to 90% of the tax should be given to state Britishers. This has created an exploitations of the marginalized or small farmers, or you can say that small communities, backward communities, those who are dependent on the land for their day to day, because there was no such industrialization, ऐसे कुछ थी नहीं. Yes or no? So what happens during this? So same persons appointed local government, they are local government. So the same persons appointed, entrusted with both the power, also act as a judiciary power, also acting as an executive. ठीक, तो ये एग्जीक्यूटिव एज एन एग्जीक्यूटिव, तभी इनका नाम डीसी है, कलेक्टर. देयर मेन फंक्शंस इज टू कलेक्ट द टैक्सेस. ब्रिटिशर्स के टाइम में तभी डीसी पड़ा इनका नाम. तो देयर मेन फंक्शन वाज टू कलेक्ट द टैक्स फ्रॉम द ब्रिटिशर्स, फॉर द ब्रिटिशर्स. सो इन द कैपेसिटी ऑफ एग्जीक्यूटिंग, ये क्या कर रहे थे? टैक्स कलेक्शन. किससे? जमींदार से. और जमींदार फिर क्या कर रहा था? यहां से टैक्स कलेक्ट करता, यहां देता, कुछ परसेंटेज यहां रखता, रेस्ट यहां ट्रांसफर करता. बट ये कंपलसरी हो गया कि आपको इतने टैक्स देना है, वेदर आपका बारिश हो, क्रॉप हो, ड्रॉट हो, कोई उससे फर्क नहीं पड़ता. 3 गुना लगान, दैट हैज टू बी गिवन. देखा आपने लगान? तो that has to be given. So this has made to exploitation started, that jamindar should be exploitative, exploiting the land, the labors, क्योंकि हर किसी की एक कैपेसिटी है for the cultivation, right? So this jamindars, what we are doing now, they have started to putting pressure on the labors. In such they are also committing crimes. ठीक, तो अब ये जो क्राइम कर रहे थे वो फिर वापस यहीं पर आ रहा था, कंप्लेन. ठीक, तो नाउ एज एन जुडिशियल कैपेसिटी व्हाट दे हैव अ पावर, इनको आप सजा दे दो जो क्राइम किया. लेकिन अगर आप इनको सजा दोगे तो फिर टैक्स कौन देगा? अरेंजमेंट तो गड़बड़ हो जाएगी. यस और नो? तो इनका मेन तो फंक्शंस कलेक्शंस का था. तो इसमें क्या होने लगा? करप्शंस बढ़ गई, इनइक्वालिटी होने लगी. नाउ डू यू अंडरस्टैंड? सो बिकॉज ऑफ दिस द पावर ऑफ द एग्जीक्यूटिव एंड जुडिशरी हैज बीन सेपरेटेड. कि कलेक्शंस आप करो, क्राइम होगा तो जुडिशरी देखेगी, क्लैश ऑफ इंटरेस्ट नहीं होगा. Yes or no? Yes. Are you getting my point? So this has, because of this jamindari system, there is an prevailing of an inequality in the country. So government want to establish an welfare state, not an egalitarian state. Welfare state. Justice देना है, social justice देना, economic, polity. Equality provide करना, opportunities and status of opportunity should be given. So how you will given an opportunity of status of opportunities or equality? By eliminating the inequalities in the system, right? So on the basis of the recommendations given by the K. Kumarappa committee, the government come up with the first Constitutional Amendment Act 1951 and abolish the Jamindari system. It has done 3 major changes into the constitutions. First, added 2 new articles, 31A, 31B. Added a new article 19 clause 1 subclause A, F, and added a new schedule, that is 9th schedule, and this 9th schedule is a schedule which is respect to the Land Act, specially made for the Land Act. So any act related to the land, abolition of zamindari, sealing of land, or any kind of a land act, so that is to be put under the 9th schedule. And this is power given to the state also. That is state, if state come also make any law related to the land, and they can put that into the 9th schedule. So what is the benefit of this? Why it is said that the Land Act should be put under the 9th schedule? Because originally, this 9th schedule was out of the purview of judicial review. It means any law which is to be put under the 9th schedule, so court has no power to review that law, or it cannot be challenged in a court of law. So it was kept outside the purview of the judicial review. Are you getting my point? I am talking about 1951. आप 2050 के बाद 2025 में ये बात क्वेश्चन मत पूछिएगा सर, ऐसा तो नहीं होता है. Still we are in 1951. So this is a case. Yes or no? This is the first Constitutional Amendment Act. Any doubt? Do you understand? इससे क्या हो गया? हाँ जी.
इसका जमींदारी खत्म हो गया, वो लोग कोर्ट नहीं जा सकते.
नहीं.
उस समय
अगर कोई भी एक्ट को 9th शेड्यूल में डाल दिया गया तो कोर्ट उसको रिव्यू नहीं कर सकती और अनकॉन्स्टिट्यूशनल नहीं बोल सकती. मैंने क्या कहा आपसे अभी? मैं पता है मुझे कि आप क्या पूछ सकते हो. तभी मैंने कहा कि अभी आपको सिर्फ 1951 के रिस्पेक्ट में ही रहना है. इज इट क्लियर? इससे क्या इफेक्ट हुआ? मैंने आपसे कहा था कि आपको बैक ऑफ द माइंड कुछ रखना अपने दिमाग में. क्या? और बस right to property. So this is a period of 1951, and right to property is a fundamental right. So this was challenged in a court. So next is Sankri Prasad case 1951. So this, under this, the first Constitutional Amendment Act was challenged. Now why it is challenged? Why it was challenged? On the ground that Article 368, whatever the first Constitutional Amendment Act, the Parliament has made law, is a violative of Article 13. So on this ground it was challenged. Are you getting my point? Yes or no? Clear? So Sankri Prasad said that Article 13, in Sankri Prasad case, the judiciary says, the court, Supreme Court says, Article 13 does not apply to Article 368. It means, it says, Parliament has a power to amend the constitutions, including fundamental right. Clear? So court has given a judgment in which favor? In Parliament favor, in 368 favor. Are you getting my point?
Yes.
ठीक है, मैं यहाँ एक टेबल बना देता हूँ आपके लिए. Article 13, Article 368. Now what we will do here, just we will mark कि किस जजमेंट में किसके फेवर में जजमेंट दे रहे. ठीक, तो शंकरी प्रसाद ने किसका फेवर किया? 368, और कहा दिस इज नॉट एप्लीकेबल. So it means it has taken a side. Yes or no? It has taken side. And it says the Parliament, while using a power under 368, can amend the constitutions and fundamental right is a part, so it can also be amended. This was said. So what does it mean? It means it has given again the power to the parliament. Yes or no? So it has given power to parliament. So parliament came up with the 17th Constitutional Amendment Act, 1964. So what is that? So it has extended the scope of 331A and added the term estate. State is an, what does it mean? Company? Nahi. Estate. Real estate. It's related to the building, property, land. दो तरीके की प्रॉपर्टी होती है, पता है आपको? वन इज मूवेबल एंड वन इज इमूवेबल. सो मूवेबल प्रॉपर्टी का एग्जांपल अगर मैं आपसे पूछूं तो व्हीकल, गोल्ड, मोबाइल फोन, अब तो वो भी प्रॉपर्टी हो गई ना. इमूवेबल प्रॉपर्टी, लैंड, हाउस. ठीक है. तो इट हैज एक्सटेंडेड द स्कोप ऑफ 31A एंड estate was included in this, and also it has amended the 9th schedule, including more law into the 9th schedule. Take this was again challenged, again on the same ground of Article 13. So next is a Sajjan Singh case 1965. So now what happened in Sajjan Singh case? It was 17th was challenged in this. And what is the ground for challenging? Again Article 13. Right to property. How you can do this? So Sajjan Singh said, now this is an 5-judge bench. 5 judges bench. The judgment came in the ratio 3:2. So what is a judgment under Sajjan Singh case? It says the Article 13 of the Constitution does not comes between Article 368. It means 13 is not applicable to 368. The power of Parliament of what? Amending the including the fundamental right. It has also added one more thing. So the Chief Justice of that period said that if the framers of the constitutions would have a view that fundamental right should not be amended or fundamental right should be kept out of the preview of the power of Parliament, they have clearly mentioned in the constitutions. But there is no such thing has been given in the Constitution. It means the Constitution does not say anything about whether the fundamental right can be amended or not. If the framers would have a view or they have an idea or opinion that no one should touch the fundamental right, that would have been kept outside the preview of Parliament to amend. So it means again the Sajjan Singh case has taken the side of 368. Yes or no? By giving an judgment in favor of 368. But it also said that though the framers does not have clearly mentioned, or they do not, if they have shown any intentions that the fundamental right should be, if not to be amended by the 368, it has to be kept outside, right? But we are referring these questions to the highest bench or higher bench. So next is Golaknath versus State of Punjab 1967. This came for the interpretations of Sajjan Singh case. Am I clear? Yes or no? Take. So this positions, Golaknath case has made the situations 180 degree turn. अभी तक क्या हो रहा था? शंकर सज्जन सिंह और शंकरी प्रसाद में क्या चल रहा था? Not applicable, you are free. Golaknath says you cannot amend the fundamental rights of Parliament. Does not have a power under 368 to amend the fundamental right. It means Article 13 comes in between 368. So it has restricted the power of Parliament to amend the fundamental right. Till here it is clear. समझ गए यहाँ तक? Any doubt? Anyone having any doubt? Any confusion? आपका क्वेश्चन है कुछ बेसिक स्ट्रक्चर?
गलतनाथ स्टेट ऑफ पंजाब लिखते हैं।
हाँ,
मतलब क्या? मतलब
गोलकनाथ कोई इंडिविजुअल आदमी है, केस के स्टेट में केस किया, हाई कोर्ट में केस किया, हाई कोर्ट ने कहा दिस इज रिक्वायर्ड एन इंटरप्रिटेशन ऑफ द कॉन्स्टिट्यूशन, सो इट इज सुप्रीम कोर्ट। और इसका दूसरा मतलब ये भी हो सकता है कि हाई कोर्ट ने जजमेंट दे दी, इसको अपील कर दिया ऊपर, तो इसलिए केस तो वही रह गया, केस नया बनेगा नहीं, उसी का अपील एपलेट फॉर्म में है ना, इसलिए सुप्रीम कोर्ट उसको जजमेंट दे रहे हैं, बिकॉज सुप्रीम कोर्ट इज एन हाईएस्ट एंड फाइनल इंटरप्रेटर ऑफ द कॉन्स्टिट्यूशंस। और कुछ पूछना था आपका?
कॉन्स्टिट्यूशनलिज्म को कोई हाईकोर्ट जजमेंट पास
कर सकता है, बट अगर उसको हाई कोर्ट को लगता है कि ये इंटरप्रिटेशन या इट रिक्वायर्स एन इंटरप्रिटेशन ऑफ द लॉ, तो यू कैन से यू कैन सर्टिफाई द जजमेंट इट रिक्वायर्स एन इंटरप्रिटेशन, क्योंकि फाइनल इंटरप्रेटर सुप्रीम कोर्ट है ना। कंफ्यूजन है तो पूछिए।
What is that Article 368 amended?
Cannot and Golaknath said using Article 368 Parliament cannot amend the fundamental right. Any doubt? Any confusion? नहीं? So ये क्या हो गया? So पार्लियामेंट के दिल के अरमा आंसू में बह गए। Now the power of parliament to amend the constitution is restricted. और इस जजमेंट के आने के बाद all the amendments were made before this judgment were also keep on challenging, because the court says parliament cannot amend. So retrospective जितने amendments है that was also kept on challenging. So it also says in the Golaknath that this will applicable prospective, not retrospective, after the date of the judgment. So whatever the amendment made by the parliament after the commencement or after the pronouncement of the judgment can only applicable to them, not to the previous amendments. ठीक? So इससे क्या हो गया? Parliament become angry. So it comes up with the next amendment, that is 24th Constitutional Amendment Act 1971. अब इन्होंने इसमें क्या किया? So now they what they do, what they think कि अब क्या करना चाहिए? Okay, court says कि you cannot do anything. Why? Because something is coming in between. तो इसका solutions क्या होगा? उस something को ही हटा दो, है ना? You are getting my point? if something is coming in between you, so what you will do, something कोई हटाओ ताकि आगे कभी कोई problem ना हो. So through this amendment, what they do, they added a clause 4 to article 13 and clause 3 to article 368. Nature of both the clauses same. So what does clause 4 of article 13 says? It says that nothing in this article shall apply to any amendment of this constitution under 368. Are you getting my point? Clause 4 says that now if any amendments made by the parliament using 368, that cannot be restricted by article 13. It has also added clause 3 to 368, which also says nothing in article 13 shall apply to any amendment under article 368. So जो बीच में रुकावट था उसको उन्होंने फेंक दिया. Now you cannot challenge on the basis of article 13. Clear? ठीक है. इसके बाद और भी 2-3 amendments आए. 25 आया. 25 is related to land act. Then it comes 26. 26 is related to privy purse. What is privy purse? Purse आपने सुना ये term? Privy purse. Privy purse. What is privy purse? Yes. जब राजाओं को हमने कहा क्या कर आप मर्ज हो जाओ आप इंडिया में, तो हमारा तो रजवाड़ा है, हम आप पे सैलरी क्यों, we have to depend on your salary. So they have created one privy purse. So this was created through 26th Constitutional Amendment Act. कि हम आप जमींदारी सिस्टम, वी आर ऑन द वर्ज टू फिनिश द जमींदारी सिस्टम, लेकिन भाई उनका इनकम, तो चलिए हम एक पर्स बना देते हैं जिसमें कुछ फंड विल बी देयर टू यूज फॉर यू. सो ऑल दीज 24th गोलकनाथ, 25th, 26th, now all of these were come into the challenge in Keswanand Bharati case, which is known as a landmark judgment in Indian history. So इसमें गोलक, this is the why it has a very many, you can say that features to be known as a landmark. First, it is the highest judge bench or largest judge bench till that today. 13 judge bench. Judgment आया था 3-7-6. Still no one or neither any judgment or a bench has been so much large of 13 judges bench. So this was the highest first. Or all of the judgment of the Golaknath, 24, 25, 26, 29, all came into the challenge in the Keswanand Bharati case. Was a state of Kerala. 1973, 24th of April. The date is very important. Why? We will discuss later. ये डेट आपको याद होना चाहिए. Now what is, who is Keswanand? Keswanand Bharati. मठाधीश. डू यू अंडरस्टैंड मठाधीश? ठीक है ना, एक मठ, हेड ऑफ द मठ इन केरल, एंड ही हैज अ वेरी ह्यूज tract of land under him. Not only tract of land, but also having many were been living on that land, supported by the income of that land. ठीक है. But due to the, देखिए CDS के एग्जाम में आप लोग ये सब पढ़ते हो, अच्छी बात है, यू नो, यू शुड ऑल्सो नो समथिंग एल्स. CDS विच इज ऑल्सो कंडक्टेड बाय द UPSC. सबने पढ़ा केशवानंद भारती में डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर आया, ये है वो है. द वेरी नॉमिनल क्वेश्चन और बेसिक क्वेश्चन CDS के इंटरव्यू में पूछा गया बाय द कैंडिडेट. डू यू नो केशवानंद भारती केस? यस सर. ओके, टेल मी समथिंग. the largest bench, doctrine of basic structure, ye wo, okay. So the question was that who won the case? Who won the case? Case one and lose the case. The case was won by the government. Government, state, जो भी आप बोल दीजिए. So the judgment was in the favor of state, not in the favor of Keswanand. So we should understand it. This question has been asked in CDS interview. कैसे वो भी मैं बताता हूँ. यहाँ तक क्लियर है? So he challenged that's all judgment. Now this is the first judgment of the judiciary who has taken a wider approach, and instead of his earlier judgment of taking anyone's side, this judgment has taken a balanced approach. He did not take a side of 368 or he did not take a side of 13. Rather, he take a balanced approach between 13 and 368. How? By pronouncing the doctrine of basic structure. So the judiciary Supreme Court says that 368 allows the parliament to make changes through amendment in the constitutions. It can amend the constitutions, including part 3 of the constitutions. But it cannot violate the doctrine of basic structure of the constitutions. Am I clear, yes or no? So it has taken up, it says that Article 13 is also not coming till you are not violating the basic structure. As you violate the basic structure, 13 will be applicable to you. Are you getting my point? So Parliament has an immense power. It can use anything under Article 368 and it can change any part of the, make any changes into the constitutions, unless and until and provided there is an this. So how this is going to, how this is acting? Doctrine of basic structure, it is an limitations. So doctrine of basic structure is what? It is a limitations. Limitation on whom? Limitations on Parliament under Article 368. And doctrine of basic structure is a doctrine which preventing the Parliament from becoming a supreme, sovereignty, supremacy. Yes or no? When it how the Parliament is not sovereign, you have to mention the doctrine of basic structure also, other than the other limitations. There are other limitations also. Article 7th schedule putting limitations. It cannot make a laws on that. So this is also one of the limitation which is imposes on the Parliament for making laws or for making changes into the constitutions, along with the 360. Am I clear? Yes or no? Any doubt? Anything you want to ask? Till here. Take. So this doctrine of basic structure is not defined and not mentioned in constitution. So it is not mentioned in constitutions. It is an judicial pronouncement. Any question? वो बता रहा हूँ, अरे ये तो रुकिए. Are you getting my point? So doctrine of basic structure is not defined, not even mentioned in the constitution. It is a judicial pronouncement. And also this has not been defined by the Supreme Court also. So Supreme Court also not defined the doctrine of basic structure. So the question was how a judiciary will know that which provisions of the constitutions come into the doctrine of basic structure, how it will come to know. So to answer these questions, the judiciary says to analyze or to scrutiny or to check any provisions whether it comes under the doctrine of basic structure or not, one has to enter into the mind of the framers of constitutions. They have to know the reason behind putting that provisions into the constitution. So what are the intentions of the framers of constitutions? Why they have put that provisions into the doctrine of basic structure. Is it clear? So this list is not been defined, this list is not been end, this list is not full, it is open list. And this is judiciary who can put any provisions of the constitution into the doctrine of basic structure that depends upon the interpretations of constitutions. Am I clear? No. क्या नहीं समझ में आपको बताइए?
To know the basic structure, we must go in the minds of the framers of the constitution. But in the constitution itself, they have not mentioned the basic structure. Then how could we guess that?
We are not no one to guess. We means Supreme Court, judiciary. So while it requires any interpretations, so while interpreting the constitutions, and if they come to know or if they come an idea the reason behind the mentions or the provisions, so the judiciary will decide whether it is a part of the basic structure or not. So यही तो मैंने कहा.
That to be which did the Supreme Court or High Court?
Supreme Court. Supreme Court is the final authority. High Court to say not any court. High Court or Supreme Court. High Court can put, but it can also refer to the Supreme Court for the interpretations. Yes or no? Any doubt? Clear? So this has been given and done. The doctrine of basic structure. Now what happened after this? So after this, similar to that of an Golaknath case, all the amendments made by the constitutions, parliament, came to be challenges in a court of law. So for this, first of all, we should see the Vaman Rao. Vaman Rao in 1980. There only this case is important only for related to the term that after the judgment of the Keswanand Bharti case, all the amendments came to be challenged, whether before or earlier challenges. So in the Vaman Rao case, the Supreme Court says that doctrine of basic structure, because this become the basis for the challenges of all the amendments on the basis of doctrine structure that was pronounced by the Keswanand. So it says that the doctrine of basic structure will only applicable after 24th of April 1973's amendments. Why this date? Because this is the date on which the Keswanand Bharti judgment was came. So it is not retrospective, rather it will be applicable to prospective, means in future, right? ठीक है, चलिए. So now what happened after this? Case 1 1973. This is a period you can understand. यहाँ पर कौन था प्राइम मिनिस्टर? इंदिरा गांधी. इलेक्शन कंडक्टेड. इसके बाद क्या होता है? इलेक्शन होता है. और द इलेक्शन ऑफ इंदिरा गांधी वॉज चैलेंज बाय राज नारायण इन Allahabad High Court. The basis was that she has the complaint, there is an allegations that Indira Gandhi has used some
government function.
not government function, but she has been miscreant in the elections, booth capturing या गलत तरीके से इन्होंने elections को जीता है. So that was challenge in Raj Narayan, Indira Gandhi and Raj Narayan. In Indira Gandhi Raj Narayan case, Allahabad High Court favored in Raj Narayan. He said the election of Indira Gandhi was invalid. Okay? So the case of Indira Gandhi Raj Narayan was challenged in a Supreme Court. इसी केस से रिलेटेड 2 इंसिडेंट्स है. ठीक है? And the major 2 incidents. Till it is clear? After 73 there was an elections and the election was challenged in Allahabad High Court. So High Court says the election of Indira Gandhi was invalid. So cancel the elections. So Indira Gandhi challenged that judgment into the Supreme Court. Before the judgment of the Supreme Court into the Raj Narayan and Indira Gandhi case, the 2 major incidents happened. First, she came up with the 39th Constitutional Amendment Act 1975 and she imposed national emergency. Is it clear? This is just before the hearing of a Raj Narayan. Take. So what she has changed through the 39th Constitutional Amendment Act? अब हम जो भी देख रहे हैं ना, now whatever you are going through the amendments or cases, that all related to one of the very major character of the judiciary, that is judicial review. How the judicial review become a part of the doctrine structure, we are discussing this. Okay? So try to understand. So this 39th Constitutional Amendment Act has make a major change. What? Now she said that the Parliament through this amendment deprive the court of judicial review. So this amendment says what? That court is no longer of what? Power of reviewing the election of president, vice president, prime minister and speaker of Lok Sabha. यानी ये जो केस हुआ था, why this case was there? Because power has judiciary has a power to review election petition. So what she did? She deprived this power of a judiciary. Okay, now you are no longer to adjudicate the dispute of elections related to president, vice president, prime minister and speaker. So which authority? It will be decided by the Parliament. So through 39th Constitutional Amendment Act, it was blow to the judicial review of an judiciary. Am I clear, yes or no?
Yes, sir.
Any doubt? Clear? So all this dispute cannot be now heard into the judiciary, cannot heard this. And after this, she imposed a national emergency on internal disturbance. So in the Raj Narayan and Indira Gandhi case, the Supreme Court says that Allahabad judgment was invalid, the election of Indira Gandhi was valid, and this 39th Constitutional Amendment Act is unconstitutional because It is depriving the judiciary from judicial review power. Are you getting my point? Yes or no? Confusion judicial review में हो? What is judicial review? We will discuss. But अभी यहाँ समझिए. Any doubt? Anyone? Is it clear? So this has also blown to the government. Election जीत जाती हैं. Elections के बाद, so next came 42nd Constitutional Amendment Act. This is the mini constitution of the, it is also known as a mini constitution. Why? ऐसा कोई भी part या article नहीं है जिसमें through this it has not been changed. So this 42nd Constitutional Amendment 1976 is added mainly 3. इसका यूज हम डायरेक्टिव प्रिंसिपल्स में भी करेंगे. So therefore that where also we need to understand. So it says, the parliament says that any provisions in part 3rd and part 4th, and if these provisions are violative of part 3rd, then also it is valid. ठीक. Plus it has granted, this is more important with respect to the fundamental right. Through 42nd Amendment Act, the parliament was granted a supremacy, supreme power under 368. It disallowed the judicial review power of an judiciary. ठीक. इसके बाद क्या होता है? सरकार गिर जाती है, फिर इलेक्शन होता है, और कौन आता है फिर? जनता गवर्नमेंट. मोरारजी देसाई एज अ प्राइम मिनिस्टर 1977 से 1978-79 तक. 80 में फिर वापस चले जाते इंदिरा गांधी. सो दे आर ओनली फॉर द 44th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. उसमें जो 42nd से गड़बड़ी हुई थी उसको चेंज करने के लिए. टिल इट इज क्लियर? सो दिस वाज चैलेंज इन मिनर्वा मिल केस. So the 42nd Constitutional Amendment Act, in this the Supreme Court says you cannot deprive the judiciary from judicial review, and it is a basic structure of the Constitution. The Parliament cannot alter the basic structure of the constitutions. That is an judicial review comes under the basic structure of the constitutions. So basic judicial review kept under the preview of basic structure. Yes or no? Any doubt? Clear? Now Vaman Rao we have discussed the cases because chose to timeline for the timeline. Just came to for the timelines. Any doubt? Any question? Clear? So this is, and by this, if you can see where we have started, amendability of the fundamental right. So we can answer now whether the parliament has a power or not, or 13 come into the place or not. So yes, 13 comes only when there is a violation of basic structure. And so Article 13 defines the law means what? So law includes ordinance, order, bylaw, rule, regulation, notification, custom. एक क्वेश्चन मैंने आपसे पूछा था, इफ यू रिमेंबर, कि इंडिया गवर्न्स थ्रू विच ऑफ द फॉलोइंग. तो आई हैव आल्सो गिवन यू द कस्टम्स. So law includes customs also, or uses having in the territory of India the force of law. Law enforce includes, and this fourth was added by 24th Constitutional Amendment Act. ठीक है? Before the commencement of constitutions. So this is an amendability of the fundamental right. Any doubt? So now the list is remaining. So write on the list. Then we will take a break, or you want a break, then you can write. बताइए जल्दी. Write then break. Then write. So write on the provisions which are under the basic structure. Supremacy of constitution. Next, sovereignty, democratic and republic nature of Indian polity. Fast लिखिए थोड़ा. Write it fast. Next, democratic, sovereignty and republic nature of Indian polity. Next is secularism, secular character of constitution, secularism. Next, separation of power. Next, federal character. Next, unity and integrity of the nation. Unity and integrity of the nations. Next, welfare state, that is socio-economic justice. Welfare state, that is socio-economic justice. Judicial review. Next, freedom and dignity of individuals. Parliamentary form of government. Rule of law. Harmony relation between third and fourth, part third and part fourth. Harmony relations. Harmony and balance relations between part third and part fourth of the constitutions. Part 4 समझ रहे हैं? DPSP, Directive Principle of State Policies. Third and fourth of the constitutions. Next is principle of equality. Principle of equality. Next, free and fair election. Next, independence of judiciary. Next, limited power of parliament under Article 368. Limited power of parliament under Article 368. Next, effective access to justice. Next, principles underlying fundamental rights. Underlying fundamental rights. Next, power of Supreme Court under Article 32. (136), 32. 136, not 32, 136, 141 and 142, 42, 142. And the last is power of high courts under article 226 and 227.
High Court.
Under article 226 and 227. 27, 226 those and 227. So these are the list. This is not end. Okay, this is not a final list. It is an open list. So if you get, if suppose that you find any more articles to be included, so you can write on. Okay, so as I said, this is not a final list. Clear? So this is so this we have come to an end to the discussion of amendability of the fundamental rights. Now we will start fundamental rights with the classifications. So as we have seen, the part 3 and part 4, part 3 of the constitutions contained items from 12, article 12 to 35. So 12 and 13 we have discussed, right? I will enter into the fundamental rights after the break. So let's take a break.